The Honorable Court of Criminal Appeals of Tennessee is now in session.
Thank you, Clerk Hibner, and welcome everyone to this call of the Tennessee Court of Criminal Appeals docket in Jackson, Tennessee. This is our third case this afternoon that we will be hearing. The rules are the same for this case as they are if you are in person, 20 minutes per side. If you wish any rebuttal, please do so upon introducing yourself to the court. The panel on this case today has been all of November in Jackson, Tennessee, covers the state jurisdiction. In the middle, we have Judge Tim Easter from Franklin. In the east, we have Judge Norman McGee Ogle from Sevierville, and I'm John Everett Williams representing the west from Huntington, Tennessee. Mr. Clerk, would you please call the next case?
State of Tennessee versus David Lemons.
Good afternoon again, Your Honors. May it please the court. Jessica Butler with the Appellate Division of the Public Defender's Conference. On behalf of the appellant in this case, Mr. David Lemons. Your Honor, if I could reserve 3 minutes for rebuttal.
Yes, ma'am, and I'll try to help you. Keep up
All right,
with
thank
it.
you so much. Mr. Lemons was convicted of 11 counts, which generally can be separated into 3 different offenses. One would be possession of a firearm, the other possession of marijuana with intent to sell or deliver in a school zone, and finally, possession of drug paraphernalia. All of these items were discovered in his home, which happened to be within 1,000 feet of a school, hence the drug-free school zone classification. I will note that all of the events in this case occurred in 2019, so this was before the recent changes to the drug-free school zone statute. Obviously, if this had happened now, Mr. Lemons would have been given the presumption that he was not the intended target of that statute. Nonetheless, Mr. Lemons was sentenced as a range 2 offender. He received an 8-year sentence for possession of marijuana in the school zone. That was the maximum available sentence. Additionally, he received a 15-year conviction or sentence for possession of a weapon. That was a mid-range sentence based on his classification. The 2 sentences were run consecutive to one another for an effective 23-year sentence. These 2 sentences were also run consecutive to a different case where he received a 15-year sentence, bringing his total amount of time to 38 years between those 2 cases. And obviously, we're not contesting that additional 15-year sentence, just the 23 years at issue in this case. And the problem with the sentence that the trial court issued in this case is that the way that the trial court reached that decision was based on a misapplication of enhancement factors, a failure to make appropriate findings on the record regarding the imposition of consecutive sentences. And I'll note that the state has largely conceded the misapplication of the enhancement factor with regard to several of the instances. There are a few places where we differ in agreement there, but the state has conceded that the trial court made some errors in applying that factor. That would be enhancement factor 8. There's at least one instance where we differ in agreement there. The state's also largely conceded that the trial court failed to place proper findings on the record regarding the consecutive sentences and has requested a de novo review with respect to several of the consecutive sentencing factors that were available to the court. So ultimately, in a lot of ways, we're in agreement. I think both sides would like for this to be resolved de novo by this trial court, by this court. I think there's enough in the record, the pre-sentence report, the sentencing hearing, for this court to conduct a de novo review. But I will start with kind of the areas where we differ in agreement, starting with enhancement factor number 8. This was a factor that allowed the trial court to enhance Mr. Lemons' sentence based on the fact that he committed new offenses while he was on some type of supervised release following a sentence, whether it be probation, parole, or community corrections. There are, I believe, somewhere around 8 or 9 instances that the trial court pointed out at the sentencing hearing where it determined that Mr. Lemons had committed new offenses while he was on one of those forms of release. In reality, there are only 2 instances where Mr. Lemons committed new offenses while he was on some type of release, whether it be probation or community corrections. The first of those instances occurred in 1997. Mr. Lemons was 19 years old. At the time of his sentencing, in this case, he was 42. The second occurred in 2009, so a decade old at the time of the sentencing hearing in this case. And the offense in that case was that Mr. Lemons drove 10 miles over the speed limit while he was on an 1129 community corrections sentence. So those are the 2 instances. And that final one in 2009 would be the essentially grave error that Mr. Lemons committed, that the trial court felt it could apply great weight to that factor and impose this 23-year sentence on that basis. So we would argue that
what happened in 2002?
Right. So there was some discussion. That's the one area where the state and I differ. There was discussion at the sentencing hearing. Defense counsel knew that would be a concern for the trial court and noted that Mr. Lemons had actually flattened his sentence for that 2002. I believe it was a 1997 conviction. He flattened his sentence by the time he committed that offense in 2002. The trial court, when it went through the sentencing hearing, mistakenly was under the assumption that Mr. Lemons was on parole at the time. He was not. He had already flattened his sentence from the 1997 conviction. So that is another instance where it does not fall within that enhancement factor 8, although the trial court believed that it did at the time.
How much time did he get for the sentence in 1997?
That was a 6-year sentence. And Mr. Lemons, although there's less than 6 calendar years between those 2 offenses, and this is something that was discussed at the sentencing hearing, but essentially between pretrial credits, good time credit, Mr. Lemons was released prior to the expiration of the full 6 calendar years.
He was released as serving his time in full? Correct.
So between pretrial credits and good time credit, he was able to flatten his sentence in under 6 calendar years. Okay. But when he was released, he was not on any type of supervision.
And that was submitted to the judge?
Correct.
Okay.
Correct. Okay. So obviously, we would argue that for the trial court to place great weight on this factor when it is very clear that it either misapprehended the language of enhancement factor 8 or somewhat commingled it with a related factor, enhancement factor 13, which was also inapplicable in this case, to impose that the 23-year sentence on that basis would be unreasonable. With regards to the consecutive sentencing factors, the only factor that the trial court placed on the record, essentially it said it was using this one factor to impose consecutive sentencing in this case, and that was the dangerous offender classification. But as the court knows, the dangerous offender classification requires the trial court to make some additional findings. It's not enough that the trial court says, I find this individual to be a dangerous offender. They also have to find that the extended sentence is necessary to protect the public against further criminal conduct and that the sentence is reasonably related to the severity of the offenses committed. The trial court did not make those findings, and the state has said as much. And this is one of those instances where the state has asked for de novo review because the Wilkerson factors that are required were not placed on the record. And again, this is the only factor that the court noted it was using in imposing consecutive sentencing in this case. And so obviously we'd argue that certainly the sentence was not reasonably related to the severity of the offense. And the trial court did not make those findings, did not place those findings on the record. And so we'd argue that the trial court could not use that as a basis for imposing a consecutive sentence. Additionally, the state in its brief has outlined several other factors that it believes there was sufficient proof in the record. Although the trial court did not use those factors to impose the consecutive sentence, the state has argued that there was evidence in the record to support a finding for those factors. And I'll just very briefly get into those. But essentially, they all boil down to this narrative that flowed through the trial court's analysis and also somewhat in the state's brief that Mr. Lemons was an individual who, for the past 20 some odd years, had essentially devoted his life to criminal activity, was a professional criminal who had devoted his life to the furtherance of some type of criminal lifestyle. And that's in the state's brief, and that's somewhat the narrative that the trial court was using at the sentencing hearing as well. But that's not supported by the record. That's not really what the pre-sentence report bears out. And again, the pre-sentence report, that is evidence that was submitted by the state in this case. And if you look at the pre-sentence report, we'd obviously encourage your honors to do so. It's very clear that Mr. Lemons is the type of individual who absolutely made some very poor choices in his early years, his young adult years. He does have several felony convictions from that time, from about the ages of 18 and 19. He served time for those offenses, came out, and was on the straight and narrow for some time. There's this kind of isolated felony conviction in 2009, which again was a decade before the most recent offenses in this case. And in the interim, what we have is a lot of very petty driving offenses, speeding, violation of seatbelt law, violation of the financial responsibility law, window tint, that kind of thing. And a lot of those I think can really kind of be encompassed as almost crimes of poverty. But I think it's very clear from the pre-sentence report that Mr. Lemons was someone who, between the time 2009 to 2019, was very much trying to turn his life around. He was employed, he had started a family, settled down, was married. This is not the type of individual that, as the trial court made it seem, had devoted his entire life to, trying to game the system and trying to gain some type of advantage through criminal activity. That's not at all the narrative that's supported by the pre-sentence report. And so on that basis, we'd ask the court to conduct a de novo review because the factors that the trial court used to impose the sentence, there are multiple errors in that regard. And also the factors that were used to impose the consecutive sentence, either the trial court did not place sufficient findings on the record, or the narrative that's put forth by the state and the trial court in the case are not borne out by the record. So at that point, you really have to question whether the analysis that the trial court used supports its finding. We'd argue that it does not. And in that instance, we'd argue that the presumption of reasonableness that the trial court enjoys with regards to its sentence, at this point, based on the multitude of errors, that presumption has to be rebutted at some point. And this is the type of situation where this court can conduct a de novo review. And we'd ask the court to do so and impose a more appropriate sentence. If the court has no other questions, I'll turn it over to the state and await rebuttal. Thank you.
Seeing none, we'll call on the general.
May it please the court, Brent Cherry for the state. In July of 2020, the defendant was convicted of various drug and weapons charges and was subsequently sentenced to a total effective term of 23 years. On appeal, the defendant argues that his sentences should be vacated because the trial court misapplied an enhancement factor, ordered consecutive sentences without appropriate findings, and ultimately abused its discretion when it imposed an effective 23-year sentence based on an erroneous assessment of the proof. Judge Allen determined, first of all, that the defendant was arraigned to multiple offender based on his 3 prior Class C felonies, which were 2 aggravated assaults and an attempted robbery, and a prior Class E felony, which was for the sale of marijuana. As enhancement factors, Judge Allen found that the defendant has a previous history of criminal convictions in addition to those necessary to establish his sentence range. Only 2 of the prior felonies are necessary to establish the defendant's range to multiple offender status. So the additional 2 felonies plus the 25 misdemeanors clearly establish a prior history of criminal convictions. And as this court well knows, we only need one of those factors to be met to warrant the enhancement. Judge Allen also found, in this case, that the defendant failed to comply with conditions of a sentence involving release into the community. And it appears that Judge Allen may have mistakenly considered some offenses committed while the defendant was on bond for this factor, which is not the same as an offense committed while on probation, parole, or on community corrections. But the pre-sentence report does indicate that the defendant was convicted of 2 misdemeanors in November of 1996 and was sentenced to community corrections. And while on release on that sentence, the defendant committed an aggravated assault and an attempted robbery in early November of 1997. So right there we have an instance where the defendant did not comply with the conditions of release. The pre-sentence report also indicates the defendant's charges for aggravated assault and attempted robbery were adjudicated in December of 1997, and the defendant was sentenced to 6 years. In September of 2002, which was within that 6-year period of the sentence, the defendant was arrested for driving under the influence. Now, Judge Allen noted that, quote, it would appear that he committed that offense while he was on parole for those aggravated assaults and attempted robbery, unquote. The record supports that. There's nothing in the record. There was some discussion about whether the sentence was flattened or not, but there's nothing in the record that I could find that really establishes that, just some commentary and some speculation. So the state would suggest that Judge Allen appropriately considered that for determining that factor. As for consecutive sentencing, the defendant challenges Judge Allen's characterization of the defendant as a dangerous offender whose behavior indicates little or no regard for human life, no hesitation about committing a crime in which the risk of human life is high. However, the record also supports findings that the defendant is a professional criminal who has knowingly devoted his life to criminal acts as a major source of livelihood, and that he is an offender whose record of criminal activity is extensive. As for the professional criminal finding, Judge Allen determined that the defendant has been a professional criminal for his entire adult life. He stated, quote, I mean, there's no question at all that he is a full-time drug dealer, unquote. The pre-sentence report indicates that since 2014, the defendant owned his own business of cutting-edge lawn care with a salary of $500 a week. But in his statement to investigators, he said he was unemployed and had no income. In his home, investigators found a money clip of $785 in cash and another $2,080 in a money bag and a mason jar. The evidence supports a finding that the defendant is a professional criminal. As far as this extensive record of criminal activity, Judge Allen found that the defendant had those 4 prior felony convictions and 25 prior misdemeanor convictions. Additionally, the defendant had 4 convictions for possession of methamphetamine with intent to sell or deliver, which were committed after the offenses of this case, but for which he prior to the sentencing in this case. Now, those offenses, since they were committed after the defendant committed the offenses of this case, those could not be considered for purposes of establishing his range. But as I pointed out in the state's brief, those can be considered and appropriately would be considered in determining whether his record of criminal activity is extensive. So we have a situation here where, contrary to the argument of the defense, this defendant has some considerable criminality recently, even after he committed the offenses of this case. So far as the dangerous offender status is concerned, the trial court did not make the appropriate Wilkerson findings on the record to support the dangerous offender status. And this court certainly has the ability to make some de novo in light of the other factors that were established. The state would suggest that really isn't necessary, and that the record supports the trial court's this case. And if the court has no questions, the state would encourage the court to affirm the judgment in this case.
Ms. Butler, you have your rebuttal.
Thank you, Your Honor. With regards to the 5 years, 6 years, whether or not Mr. Lemons was on parole at the time, I will note, yes, there is some discussion. There's not specifically, a judgment or anything in the record. But I did cite a case in my brief, State versus Dean, where this court has actually said that where the trial court does not have explicit knowledge that an individual violated their parole in some way, they cannot infer that the individual did. Certainly the pre-sentence report does not state that Mr. Lemons violated his parole. Defense counsel explained kind of the discrepancy and the timing there, and yet the trial court simply ignored it and inferred what it decided was in the record, despite no evidence to support that. So that's
Is that case cited in your brief?
Yes, Your Honor. It's State versus Dean. It's cited in my brief, page 19. Here, I think we have a situation where, again, the state has acknowledged that there were several issues here with regards to the sentence, that either the trial court did not apply factors in the way that it should have, or it misapplied the factors that it did use. And I think the broader question here is that at some point, those issues, those mistakes have to reach a critical mass wherein we have to question the validity of the trial court's sentence. Essentially, if there are so many errors, what was the trial court's sentence based on? And does that rationale hold up in light of those multiple errors? Obviously, we would contend that it does not. And that's why we've asked the court to conduct a de novo review. And we think that the record is sufficient to allow this court to conclude that the sentence that was imposed, the 23 years, was excessive. So we'd ask the court to conduct a de novo review and impose a more appropriate sentence. Thank you, Your Honors.
Thank you both. Generally, at the close of the day, we have one other matter pending, but at the close of a session, I like to ask my colleagues if they wish to say anything to close out the session. Judge Easter, you have anything?
Well, since you're asking, appropriate.
Let them break. All right, go break.
Yahoo.
How about you, Judge Ogle? Would you have
Thank
any
you.
closing remarks?
I'm totally in agreement with Judge Easter.
Very well. I would want to congratulate both of you on briefs and arguments. The one thing we really enjoy is when it's over, I know where each of you stand and I know what I've got to answer for you. And you have both presented your sides very well. I think I understand them now. I've got to do a little work and think about both of your arguments a little bit longer. So with that, we'll stand in recess till 4 o'clock. Thank you.
This honorable court is now in recess until 4 p.m.